Referring to you now, my dear friends, advance ruling under the GST. Authority for advance ruling is set up for each state. We have the authority for advance ruling. Nowadays, a number of pronouncements are coming from the AAR, Authority for Advance Ruling. Sometimes AAAR, Appelate Authority for Advance Ruling. Many occasions I have been referred to you as per the Authority for Advance Ruling of Andhra Pradesh, Authority for Advance Ruling of Karnataka, Authority for Advance Ruling of Gujarat. Like that I used to refer. I referred also. So, what is this particular Authority for Advance Ruling, AAR? First and foremost, one should understand, my dear, there are two different appealable routes to go for want of justice. See, a person who got aggrieved with the order, let us say, he is a taxpayer who received the order from the adjudicating authority, order where total tax demanded 1,60,000 plus the tax portion plus interest portion, for example, totally 2,50,000 rupees of demand confirmed by the officer, namely adjudicating authority, which is competent to issue this particular order issued, and the taxpayer received this particular order. Now here what happened, my dear, in front of the taxpayer, for him there are basically two routes of appeal to go for appeal. In front of him there are two possibilities for appeal. One is appeal to judiciary appeal, namely the Joint Commission of Appeals or the Commission of Appeals to the level of the Supreme Court of India. Just now we referred that for your kind consideration, you understood. Other one is called advance ruling. The two are two separate routes. If a person, taxpayer, file the case here, he can come back here. If this fellow file the case here and he cannot come to this side, these two are two different routes, mutually exclusives. One apply, other one won't apply. This apply, it won't apply. If it applies, it won't apply. Having this introduction to the authority for advance ruling, I am referring here. The taxpayer or a particular person here who can go for advance ruling, not only a registered person, a particular unregistered person also can go for advance ruling. In the next year, I am planning to start a business. Next year, I am planning to go for registration. Next year, if I did so, there may be so and so output. Is it taxable 18% or 5%? Today itself I got a doubt. I have not commenced the business also. I have not started my business. In spite of that, though I may be an uninsured person, Am I eligible to go for advance ruling? Yes. Advance ruling is nothing but knowing the law in advance. So, having this concept, the question on which the advance ruling, the question on which advance ruling is sought against the order of commissioner or before the issuance of order, as the case may be. It means to say that, my dear friends, a person who received the order against which one can go for advance ruling, or a person who is not received any order, who is not commenced the business, who may not be a registered person, also can go for advance ruling, is the meaning of it. Having that presenting here, what are the issues one can able to get ruling in advance from advance ruling, authority for advance ruling? The following issues only allowed to consider by authority for advance ruling. Classification issues, classification disputes will be here by the authority for advance ruling. Applicability of notification, non-applicability of a notification, to grant the exemption, not to grant the exemption, are eligible to claim refund, not to claim a refund based on the notification. If that dispute comes into picture, one can go for advance ruling to know the law in advance. Determination of the time and value of supply comes into picture. Time of supply dispute, value of supply disputes, one can ask for ruling from authority for advance ruling. Admissibility of the input tax credit of the tax paid or deemed to have been paid, not eligible to claim input tax credit, or eligible to claim input tax credit, whether eligible or not, one can ask for ruling. Determination of the tax liability to pay, determination of the liability to pay tax, determination of the liability to pay the tax. Liability to pay the tax in certain cases. In the last class I referred to you by saying that if X, Y, Z are partners, partnership firm, Z has retired, even after retirement, the liability arises for the partnership firm where the X, Y is not able to pay, even the retired partner has to pay. Z says, why should I pay? Have you informed after your retirement to the department? No, sir. It is said by the firm, firm is going to inform, therefore I have not informed, sir. Firm also not informed, then therefore is negligence of the X and Y, not my. Like that, the dispute comes into picture. If that is the case, one can ask for the justice from the authority for advance ruling. Whether applicant is required to be registered or not to be required to registered, registration is required category or not category, should be in doubt that particular dispute. One can ask for clarification from the advance ruling. Whether any particular thing done by the applicant amount to supply or not a supply, it come under the scope of supply or not a supply, or if a supply, it is exempt supply or taxable supply, or it is a supply excluded from the scope of supply. Such a dispute comes into picture, one can ask for authority for advance ruling. These are the issues only can ask for authority for advance ruling. I put in the last here, see, full stop, meaning what? That's it. These are the points only can refer in the authority for advance ruling. Sir, what about place of supply dispute? No, place of supply dispute, authority for advance ruling not going to be considered from hearing. It is only a tribunal, from there directly to go to Supreme Court. Place of supply disputes not going to hear by authority for advance ruling. Now, appeal procedure. Appeals to authority for advance ruling, in that case, the applicant, point number 1, point number 2, like that, points I mentioned, point number 2, 3, 4, 5, it goes like that, in an arrow mark, simplified manner to make you understand. Look here. First point, the application for obtaining advance ruling shall be made on the common portal in the form GST AAR 01, AAR 01, application for authority for advance ruling. It shall be accompanied a fee of rupees 5,000, equal amount of SGST 5,000, total amount of 10,000, which is appealable fee paid to the advance ruling. Authority for advance ruling is a fee payable to a court or tribunal, absolutely not attract GST. And the relevant documents as may be prescribed. The application must contain the question upon which the advance ruling is sought. It must be supported by the statement of relevant facts bearing on the question raised. Statement of facts should be mentioned. Further, step 2. The applicant must state in the application his interpretation to the law and or facts in respect of the question upon which advance ruling has been sought by him. What is your stand? Hey, Mr. Applicant, you apply for the want of advance ruling, correct? Facts of the case you mentioned, correct? Having these facts of the case, what is your point? Sir, my point is the applicability of exemption notification is applicable, sir, for me. My interpretation is this, sir. Department is not accepting, sir. Like that, you have to state your stand. Further, step 3. The application must not contain a question which is pending under any proceedings in the applicant's case under the Act. Sir, I already filed the case where in the GST tribunal. There, the GST tribunal is taken up my application from hearing and their hearing. In that case, the points of dispute which is hearing by the GST tribunal, those points I should not ask in the authority for advance ruling, which was already decided in any proceedings in the applicant case under this provision of this Act. I told you already, sir, in the given case what happened, a taxpayer filed the case against the order in the judicial route, Joint Commissioner Appeals. He filed the appeal. There he got defeated and went to tribunal. In the tribunal also got defeated. That means tribunal said you have to pay the amount, and that applicant want to challenge it in the other for advance ruling. Not possible, because the matter already settled by the tribunal and the same cannot be again asked for justice in the authority for advance ruling. Is the point of this step number 3. The question is the application must not contain a question which was already decided in any proceeding in the applicant case under the provision of this Act. Further, step 4. Step 4. Referring here. On receipt of the application, the authority will examine it and may call for the relevant records. The authority after hearing the applicant and concerned officer may either accept the application from hearing or reject the application from hearing. So both the parties stand after taking into account. The authority for advance ruling will finally take decision. Okay, I am going to proceed to hear the case, or the matter already decided by the High Court. The same point you are asking me here, sorry, take away, go, because your case already you filed the case in the High Court. High Court gave judgment against you, and the same point you are coming and asking me to give the clarification or decision. We cannot be able to provide. Your application from hearing rejected, or a fresh case with regard to, yes, no, the case belongs to places of play. Sorry, we are not competent to hear. Reject. Further, my dear friends, if they accepted from hearing, then step 5 will come into picture. If they accepted from hearing, when the application is accepted by the authority will pronounce its ruling within a period of 90 days. Within a period of 90 days from the receipt of the application. Maximum 9 days time period is going to be considered for providing the justice decision. The same will be after giving the due opportunity of being heard to all parties to the ruling. The advance ruling will be binding upon the applicant and the concerned jurisdictional officer. Very important to note. This particular advance ruling is binding upon whom? On the applicant and concerned jurisdictional officer. That means binding upon the applicant and the concerned jurisdictional officer. Meaning what? I will tell you with an example. We will appreciate here the example what I am trying to present here. Dear sir, a case where Rafi Academy and Commissioner of CT, Central Tax, is the two parties. This fellow went for AAR, Tamil Nadu. AAR given decision. This decision is to whom applicable? Applicable to Rafi Academy and the commissioner, of Central Tax. That's it. Sir, Rafi and Associates, sir. Rafi and Associates, where is a sister concern of Rafi Academy, sir. So what? Rafi and Associates, for you, this decision not applicable. Sir, facts of the case remain same, sir. So what? Not applicable. Sir, Rafi Academy and Rafi Associates are sister concerns, sir. So what? Not applicable. Rafi Academy separate, Rafi and Associates separates. Though the facts of the case remain same, the decision is applicable only to applicant and the department. Applicant and department. Then Rafi and Associates wanted to get the ruling. What should they do? They should apply again. Fresh application. Form GST AAR 01 application for advance ruling. By paying again fees. CGST rupees 5,000, SGST 5,000, 10,000 fees has to pay, application fees, and get separate ruling. Is the meaning of it. Further, finally, the appeal, if the decision is given here, AAR given the decision against applicant. I am the applicant, Rafi Academy. Rafi Academy got hurt. Oh, sir, AAR, you are not giving the justice to me. I got hurt, aggrieved. Can I go for appeal to any higher authority against the order of AAR? Yes. Against the order of AAR, one can go to authority for here one can go to the higher authority, where it is called as AAR. One can file the appeal to AAR. AAR to AAR. AAR means Authority for Advance Ruling. Against that ruling, one can go to appeal to Appellate Authority for Advance Ruling. Now, AAR, I am bringing to notice AAR. Step by step approach. Appeal to Appellate Authority for Advance Ruling, AAAR, AAR. Here, step 6, presenting here, step 6. Any party aggrieved by the ruling may prefer an appeal to the Appellate Authority within 30 days of its communication to him from AAR to AAAR 30 days time period to appeal. Such period may be extended further period of 30 days by the Appellate Authority on befitting grounds. The matter has merit. Delay happened within 30 days from AAR, not able to apply to AAR. In that case, for befitting perfect reasons cases, the 30 days time period further can be condoned by the AAR. If the appeal is made by the applicant, then it must be made in form GST ARA 02 and be accompanied with a fee of rupees 10,000 as per the CGST, SGST 10,000, together 20,000. Further, if the appeal is made by the concerned jurisdictional officer, then it must be in the form GST ARA 03 and no fees is payable. The application fees for appeal is applicable to the taxpayer or the a particular person, not to department. So appellate fees 10,000 plus 10,000 20,000 is absolutely not attract the GST. Further, point number 7, step number 7. The Appellate Authority shall within 90 days from the date of filing the appeal and after giving the due opportunity of being heard to both the parties will pass the order. Further, if the members of the Appellate Authority differ on any point or points referred to in the appeal or reference, it shall be deemed that no advance ruling can be issued in respect of the question under appeal or reference. I will tell you here. Mr. A, Mr. B, Mr. C are the panel in the AAAR judiciary by hearing case. They got what we can call their opinions in the given case are differing from other. Mr. A says acceptable, Mr. B not acceptable, C is dilemma, it is not that and this, like that. There is a no unanimous decision comes into picture. Who are the judiciary listening or hearing the case, then they will reject as if it is not an application made to AAR. In that case, what happened generally? The authority or appellate authority may amend any order passed by it under the so and so sections so as to rectify any error apparent on the face of the records within a period of 6 months from the date of the order, provided no rectification having been effect of enhancing the tax liability unless opposition of being heard is given. What is the entire story here? It says that the earlier one is, this one is within 90 days they will dispose the case by giving decision. If not able to provide, confusion arises, they dispose as if there is no appeal made to AAR. Now, in the given case of step 8, if the decision is given by authority for advance ruling or by appellate authority for advance ruling, decision is given, after giving the decision, there is an apparent error that can be rectified within a period of 6 months from the date of passing the order. But on account of rectification of mistake, you want to enhance the liability, that can be done only after giving an opportunity of being heard to both the parties. Further, advance ruling will be void ab initio if obtained by the applicant or the appellant by means of fraud, misrepresentation, suppression of facts, etc. On these grounds, if you obtained the advance ruling in your favor, which noticed by the advance ruling later, then the ruling is given to you will not be valid. Is the way in which it has been structurized. Further bringing to a notice, this particular page, what is there here, 400, page number 400, this appeal to National Appellate Authority is yet to formulate, which is not applicable for our November 2023 as well as December 2023 examination, because not formulated. In the case where the conflict arises while disposing the case, and that matter further can be referred in the National Appellate Authority, which is under NAA, which is it is yet to be formulated. Maybe it is functionalized, notified, may apply for the next May 2024 or June 2024 exam onwards, if it is notified within the time period applicability. Otherwise, it is as of now not apply to your exam point of view. Conflict advance ruling taken place, then the National Appellate Authority will hear the case and dispose the case. What is the disposal of the case here is this: the appeal should be within period of 30 days, that is 90 days in case of departmental appeal. Appeal should be filed in the office of the National Appellate Authority within 30 days by appellant, taxpayer or any person. Departmental appeal, 90 days time period is there. Delay in filing the appeal can be condoned by the National Appellate Authority for the period of 30 days. The order shall be passed as far as possible within a period of 90 days from the date of receipt of the application from hearing. If the members of the NAA differ in opinion on any point, it shall be decided according to the opinion of the majority. Majority opinion will be prevailed. If the three of them are judiciary, then 2:1 ratio basis, this particular decision will be passed by NAA, National Appellate Authority.